Chapter 2. Parliament and Non-Sovereign Lawmaking Bodies. In my last chapter, I dwelt upon the nature of parliamentary sovereignty. My object in this chapter is to illustrate the characteristics of such sovereignty by comparing the essential features of a sovereign parliament like that of England with the traits which mark non-sovereign lawmaking bodies. Characteristics of sovereign parliament. The characteristics of parliamentary sovereignty may be deduced from the term itself, but these traits are apt to escape the attention of Englishmen who have been so accustomed to live under the rule of a supreme legislature that they almost without knowing it assume that all legislative bodies are supreme, and hardly therefore keep clear before their minds the properties of a supreme as contrasted with a non-sovereign lawmaking body. In this matter, foreign observers are, as is natural, clearer sighted than Englishmen. Delhomme, Naist, and Tocqueville seize at once upon the sovereignty of Parliament as a salient feature of the English Constitution, and recognise the far-reaching effects of this marked peculiarity in our institutions. Tocqueville writes, "In England, the Parliament has an acknowledged right to modify the Constitution. As, therefore, the Constitution may undergo perpetual changes, it does not in reality exist. The Parliament is at once a legislative and constituent assembly." His expressions are wanting in accuracy and might provoke some criticism, but the description of the English Parliament as at once a legislative and a constituent assembly supplies a convenient formula for summing up the fact that Parliament can change any law whatever. Being a legislative assembly, it can make ordinary laws. Being a constituent assembly, it can make laws which shift the basis of the Constitution. The results which ensue from this fact may be brought under three heads. First, there is no law which Parliament cannot change, or, to put the same thing somewhat differently, fundamental or so-called constitutional laws are under our Constitution changed by the same body and in the same manner as other laws, namely by Parliament acting in its ordinary legislative character. A bill for reforming the House of Commons, a bill for abolishing the House of Lords, a bill to give London a municipality, a bill to make valid marriages celebrated by a pretended clergyman, who is found after their celebration not to be in orders, are each equally within the competence of Parliament. They each may be passed in substantially the same manner. They none of them, when passed, will be, legally speaking, a whit more sacred or immutable than the others, for they each will be neither more nor less than an Act of Parliament, which can be repealed as it has been passed by Parliament, and cannot be annulled by any other power. Secondly, there is under the English Constitution no marked or clear distinction between laws which are not fundamental or constitutional, and laws which are fundamental or constitutional. The very language, therefore, expressing the difference between a legislative assembly, which can change ordinary laws, and a constituent assembly, which can change not only ordinary but also constitutional and fundamental laws, has to be borrowed from the political phraseology of foreign countries. This absence of any distinction between constitutional and ordinary laws has a close connection with the non-existence in England of any written or enacted constitutional statute or charter. Tocqueville, indeed, in common with other writers, apparently holds the unwritten character of the British Constitution to be of its essence.
L'Angleterre n'ayant point de constitution écrite, qui peut dire qu'on change sa constitution?
But here Tocqueville falls into an error, characteristic both of his nation and of the weaker side of his own rare genius. He has treated the form of the Constitution as the cause of its substantial qualities, and has inverted the relation of cause and effect. The Constitution, he seems to have thought, was changeable because it was not reduced to a written or statutory form. It is far nearer the truth to assert that the Constitution has never been reduced to a written or statutory form, because each and every part of it is changeable at the will of Parliament. When a country is governed under a constitution which is intended either to be unchangeable or at any rate to be changeable only with special difficulty, the constitution, which is nothing else than the laws which are intended to have a character of permanence or immutability, is necessarily expressed in writing or, to use English phraseology, is enacted as a statute. Where, on the other hand, every law can be legally changed with equal ease or with equal difficulty, there arises no absolute need for reducing the Constitution to a written form, or even for looking upon a definite set of laws as specially making up the Constitution. One main reason, then, why constitutional laws have not in England been recognised under that name, and in many cases have not been reduced to the form of a statutory enactment, is that one law, whatever its importance, can be passed and changed by exactly the same method as every other law. But it is a mistake to think that the whole law of the English Constitution might not be reduced to writing and be enacted in the form of a constitutional code. The Belgian Constitution, indeed, comes from very near to a written reproduction of the English Constitution, and the Constitution of England might easily be turned into an Act of Parliament without suffering any material transformation of character, provided only that the English Parliament retained, what the Belgian Parliament, by the way, does not possess, the unrestricted power of repealing or amending the constitutional code. Thirdly, there does not exist in any part of the British Empire any person or body of persons, executive, legislative, or judicial, which can pronounce void any enactment passed by the British Parliament on the ground of such enactment being opposed to the Constitution, or on any ground whatever, except, of course, its being repealed by Parliament. These then are the three traits of parliamentary sovereignty as it exists in England. First, the power of the legislature to alter any law, fundamental or otherwise, as freely and in the same manner as other laws. Secondly, the absence of any legal distinction between constitutional and other laws. Thirdly, the non-existence of any judicial or other authority having the right to nullify an act of Parliament or to treat it as void or unconstitutional. These traits are all exemplifications of the quality which my friend Mr. Bryce has happily denominated the flexibility of the British Constitution. Every part of it can be expanded, curtailed, amended, or abolished with equal ease. It is the most flexible polity in existence, and is therefore utterly different in character from the rigid constitutions, to use another expression of Mr. Bryce's, the whole or some part of which can be changed only by some extraordinary method of legislation. Characteristics of non-sovereign law-making bodies. From the attributes of a sovereign legislature, it is possible to infer negatively what are the characteristics, all or some of which are the marks of a non-sovereign law-making body, and which therefore may be called the marks or notes of legislative subordination. These signs by which you may recognise the subordination of a lawmaking body are, first, the existence of laws affecting its constitution, which such body must obey and cannot change. Hence, secondly, the formation of a marked distinction between ordinary laws and fundamental laws, and lastly, the existence of some person or persons, judicial or otherwise, having authority to pronounce upon the validity or constitutionality of laws passed by such lawmaking body. Wherever any of these marks of subordination exist with regard to a given lawmaking body, they prove that it is not a sovereign legislature. Observe the use of the words lawmaking body. This term is here employed as an expression which may include under one head both municipal bodies such as railway companies, school boards, town councils and the like, which possess a limited power of making laws but are not ordinarily called legislatures, and bodies such as the parliaments of the British colonies, of Belgium or of France, which are ordinarily called legislatures but are not in reality sovereign bodies. Footnote, which may include under one head. Footnote, this inclusion has been made the subject of criticism. The objections taken to it are apparently threefold. First, there is, it is said, a certain absurdity in bringing into one class things so different in importance and in dignity as, for example, the Belgian Parliament and an English school board. This objection rests on a misconception. It would be ridiculous to overlook the profound differences between a powerful legislature and a petty corporation, but there is nothing ridiculous in calling attention to the points which they have in common. The sole matter for consideration is whether the alleged similarity be real. No doubt when features of likeness between things which differ from one another both in appearance and in dignity are pointed out, the immediate result is to produce a sense of amusement, but the apparent absurdity is no proof that the likeness is unreal or undeserving of notice. A man differs from a rat, but this does not make it the less true or the less worth noting that they are both vertebrate animals. Secondly, the power of an English corporation, it is urged, can in general only be exercised reasonably, and any exercise of them is invalid which is not reasonable, and this is not true of the laws made, e.g. by the Parliament of a British colony. The objection admits of more than one reply. It is not universally true that the by-laws made by a corporation are invalid unless they are reasonable, but let it be assumed, for the sake of argument, that this restriction is always, as it certainly is often, imposed on the making of by-laws. This concession does not involve the consequence that by-laws do not partake of the nature of laws. All that follows from it is a conclusion which nobody questions, namely, that the powers of a non-sovereign law-making body may be restricted in very different degrees. Thirdly, the bylaws of a corporation are, it is urged, not laws because they affect only certain persons, e.g., in the case of a railway company, the passengers on the railway, and do not, like the laws of a colonial legislature, affect all persons coming under the jurisdiction of the legislature, or to put the same objection in another shape, the bylaws of a railway company apply, it is urged, only to persons using the railway, in addition to the general law of the land, by which such persons are also bound, whereas the laws, e.g. of the New Zealand Parliament, constitute the general law of the colony. The objection is plausible, but does not really show that the similarity insisted upon between the position of a corporation and, e.g., a colonial legislature is unreal. In either case, the laws made, whether by the corporation or by the legislature, apply only to a limited class of persons and are liable to be overridden by the laws of a superior legislature. Even in the case of a colony so nearly independent as New Zealand, the inhabitants are bound first by the statutes of the Imperial Parliament and in addition thereto by the acts of the New Zealand Parliament. The very rules which are bylaws when made by a corporation would admittedly be laws if made directly by Parliament. Their character cannot be changed by the fact that they are made by the permission of Parliament through a subordinate legislative body. The council of a borough, which for the present purpose is a better example of my meaning than a railway company, passes in accordance with the powers conferred upon it by Parliament a bylaw prohibiting processions with music on Sunday. The same prohibition, if contained in an Act of Parliament, would be admittedly a law. It is none the less a law because made by a body which is permitted by Parliament to legislate. End of footnote. The reason for grouping together under one name such very different kinds of lawmaking bodies is that by far the best way of clearing up our ideas as to the nature of assemblies which, to use the foreign formula, are legislative without being constituent, and which therefore are not sovereign legislatures, is to analyse the characteristics of societies, such as English railway companies, which possess a certain legislative authority, though the authority is clearly delegated and subject to the obvious control of a superior legislature. It will conduce to clearness of thought if we divide non-sovereign lawmaking bodies into the two great classes of obviously subordinate bodies such as corporations, the Council of India, etc., and such legislatures of independent countries as are legislative without being constituent, i.e. are non-sovereign legislative bodies. The consideration of the position of the non-sovereign legislatures, which exist under the complicated form of constitution known as a federal government, is best reserved for a separate chapter. Subordinate lawmaking bodies. Corporations. An English railway company is as good an example as can be found of a subordinate lawmaking body. Such a company is in the strictest sense a lawmaking society, for it can, under the powers of its act, make laws, called bylaws, for the regulation, inter alia, of travelling upon the railway, and can impose a penalty for the breach of such laws which can be enforced by proceedings in the courts. The rules, therefore, or bylaws, made by a company within the powers of its act are laws in the strictest sense of the term, as any person will discover to his own cost who, when he travels by rail from Oxford to Paddington, deliberately violates a bylaw duly made by the Great Western Railway Company. But though an English railway company is clearly a lawmaking body, it is clearly a non-sovereign lawmaking body. Its legislative power bears all the marks of subordination. First, the company is bound to obey laws and, amongst others, the Act of Parliament creating the company, which it cannot change. This is obvious and need not be insisted upon. Secondly, there is the most marked distinction between the Act constituting the company, not a line of which can be changed by the company, and the bylaws which, within the powers of its Act, the company can both make and change. Here we have on a very small scale the exact difference between constitutional laws which cannot, and ordinary laws which can, be changed by a subordinate legislature, i.e. by the company. The company, if we may apply to it the terms of constitutional law, is not a constituent, but is within certain limits a legislative assembly, and these limits are fixed by the constitution of the company. Thirdly, the courts have the right to pronounce, and indeed are bound to pronounce, on the validity of the company's bylaws, that is, upon the validity, or to use political terms, on the constitutionality of the laws made by the company as a lawmaking body. Note particularly that it is not the function of any court or judge to declare void or directly annul a bylaw made by a railway company. The function of the court is simply, upon any particular case coming before it which depends upon a bylaw made by a railway company, to decide for the purposes of that particular case whether the bylaw is or is not within the powers conferred by Act of Parliament upon the company, that is to say, whether the bylaw is or is not valid, and to give judgment in the particular case according to the court's view of the validity of the bylaw. It is worthwhile to examine with some care the mode in which English judges deal with the inquiry whether a particular bylaw is or is not within the powers given to the company by Act of Parliament, for to understand this point goes a good way towards understanding the exact way in which English or American courts determine the constitutionality of acts passed by a non-sovereign legislature. The London and North Western Railway Company made a bylaw by which, quote, any person travelling without the special permission of some duly authorised servant of the company in a carriage or by a train of a superior class to that for which his ticket was issued is hereby subject to a penalty not exceeding 40 shillings and shall, in addition, be liable to pay his fare according to the class of carriage in which he is travelling from the station where the train originally started, unless he shows that he had no intention to defraud. End quote. X, with the intention of defrauding the company, travelled in a first-class carriage instead of a second-class carriage for which his ticket was issued, and having been charged under the bylaw was convicted in the penalty of 10 shillings and costs. On appeal by X, the court determined that the bylaw was illegal and void as being repugnant to 8 Victoria C20 section 103, or in effect to the terms of the Act incorporating the company, and that therefore X could not be convicted of the offence charged against him. A bylaw of the South Eastern Railway Company required that a passenger should deliver up his ticket to a servant of the company when required to do so, and that any person travelling without a ticket or failing or refusing to deliver up his ticket should be required to pay the fare from the station whence the train originally started to the end of his journey. X had a railway ticket enabling him to travel on the South Eastern Railway. Having to change trains and pass out of the company station, he was asked to show his ticket and refused to do so, but without any fraudulent intention. He was summoned for a breach of the bylaw and convicted in the amount of the fare from the station whence the train started. The Queen's Bench Division held the conviction wrong on the ground that the bylaw was for several reasons invalid, as not being authorised by the Act under which it purported to be made.